Call this meeting of the working group to order. Madam Clerk, would you take the roll of the Senate?
Senator Agberry is present. Senator Hensley is present. Senator Powers is present. Senator White is present. Chairman Lundberg
Here.
is present. Mr. Chairman, you have 5 Senate members present.
Thank you, Madam Clerk. Would you take the roll of this House?
Representative Glenn. Here. Representative Hill. Here. Representative Reagan.
Here.
Representative Slater.
Here.
Chairman Moody.
Here.
You have 5 members present.
Thank you very much. Thank you, committee. I think the past couple of days have been interesting, eye-opening, and engaging, a good part of the process. To the audience, I thank you for being here. As you have probably heard, if you were here before, your signs are welcome. We ask that you keep them basically below your chin, not to obstruct your face, or hold them over your head, which could block the view of the people behind you, or if you hold them to the side, the same. And I appreciate your respect of the committee. Any personal orders to come before the body before we begin? See none. Happy to welcome Austin Reed from NCSL, the National Conference of State Legislatures. If you want to make your way up, yeah, I'll be candid on a personal order because I've been a part of NCSL, I want to say, for nearly 2 decades, I believe. And Austin and I have run into each other as we were chatting this morning in so many other states. I think this is the first time we have actually gotten together in Tennessee and in Nashville. And your first visit to Nashville and the capital, we welcome you here. And without objection, the floor is yours, Austin.
Thank you. This is not my first time in Nashville, but first time at the Capitol.
Very well. Thank you for the correction.
Nashville is quickly becoming among my favorite cities, and that's not flattery just for this context. It's personal opinion. Well, good morning. I have an old-fashioned testimony for you, just remarks, no slides. Happy to take questions after, but at any time, feel free to interrupt that. Go ahead and start the testimony. So I thank you for the invitation to testify before this task force. My name, as mentioned, is Austin Reed, and I'm the Senior Legislative Director for Education Policy at the National Conference of State Legislatures. NCSL represents the legislatures in the states, territories, and commonwealths of the United States. Its mission is to advance the effectiveness, independence, and integrity of legislatures and to foster interstate cooperation and facilitate the exchange of information among legislatures. NCSL also represents legislatures in dealing with the federal government, especially in support of state sovereignty and state flexibility and protection from unfunded federal mandates and unwarranted federal preemption. These 2 dual purposes, both supporting the effectiveness of legislatures and advocating for their collective interest on federal policy matters, shapes my role as a legislative director. In this role, I serve as both NCSL's lead analyst of federal education policy and serve as the lead representative on education matters before Congress and the administration, including primarily the U.S. Department of Education. As part of my duties in representing NCSL before the federal government, I staff the NCSL Standing Committee on Education, a body of legislatures and legislative staff that are selected by their legislature's leadership to develop positions on state federal issues to guide NCSL's lobbying efforts in Washington, D.C. NCSL's federal affairs staff lobby the Congress, the White House, and the federal agencies for the benefit of state legislatures in accord with the policy directives and resolutions recommended by the standing committees and adopted at the annual NCSL business meeting. All policy directives and resolutions must be approved by 3/4 of states present at the business meetings. I want to recognize that many members of this task force also serve as members of the NCSL Standing Committee on Education. While committee members explore issues that states have to deal with, committees do not recommend policy to the legislatures on issues that are internal to the states. As a general matter, NCSL does not make recommendations on state policy. We do offer nonpartisan policy analysis and facilitate exchanges between states. I provide this preamble because I believe it is important context for the testimony that I will offer today. So the matter before you, whether to continue receiving federal aid for education, is a very complicated question. With regards to the 4 primary charges of this task force, my testimony will mainly address items 2 through 4. Relating to item 2, on the requirements of federal law, I will offer frameworks for understanding federal programs for elementary and secondary education, including the requirements for participating in these programs, as well as the prohibitions on federal authority that are expressed in federal law. Relating to item 3, on the feasibility of rejecting federal education funds, I will provide background on how other states have considered this matter and briefly describe the consequences of noncompliance with federal education law. And finally, related to item 4, on strategies for rejecting federal education funding, I will offer perspectives on how state concerns with federal policy might be addressed through various avenues. And this will include a summary of NCSL's own positions on federal education policy, which represent the collective interests of state legislatures, which we hope include Tennessee's as well. So, starting with the first part, I want to begin talking through the conditions and requirements for participating in federal elementary and secondary education programs. There are numerous laws and programs that promulgate requirements for how state and local authorities manage and govern their elementary and secondary system and schools. I would generally categorize these requirements as being rooted in 2 main sources. First source, as conditions for receiving funding through federal education grant programs, such as Title I of the Elementary and Secondary Education Act. And 2, as requirements of education-related and broader civil rights laws, such as Title IX, that apply to programs and activities that receive any form of federal financial assistance. After reviewing these requirements, I will also outline a number of prohibitions on federal authority and education that are outlined in federal statute. So starting with conditions and requirements of federal education grants. So for my analysis of these various grant programs, I'm choosing primarily to focus on programs that are administered by the U.S. Department of Education. As I think was noted in previous testimony, there are other major federal programs that impact schools, such as the National School Lunch and Breakfast Program, Medicaid, and the Workforce Innovation and Opportunity Act that are operated and implemented by other federal agencies. There are the 2 most significant federal programs for elementary and secondary education are the Elementary and Secondary Education Act, most recently reauthorized by Congress as the Every Student Succeeds Act in 2015, and the Individuals with Disabilities Education Act, otherwise known as IDEA, which was last reauthorized in 2004. There are other federal programs that provide support to states for elementary and secondary education, and they include the Carl D. Perkins Act, which provides federal support for career and technical education, the McKinney-Vento Education for Homeless Children and Youth Program, which provides federal support for homeless children and youths, and the Education Sciences Reform Act, which, among other purposes, provides federal support for statewide longitudinal data systems. So let's get into the Elementary and Secondary Education Act, known as ESEA. I will refer to it as ESEA throughout this testimony. It contains multiple programs offering federal aid for education, including Title I, which is the most known, which is programs for disadvantaged students in order to provide all children, I'm quoting, to provide all children significant opportunity to receive a fair, equitable, and high-quality education and to close educational achievement gaps. There's Title II, which is programs for teachers, principals, and school leaders, literacy, American history, civics, and education. There's Title III, which is programs to support English language acquisition for English learners. There's Title IV, which are programs to provide to support a well-rounded education, safe and healthy students, and technology. There's after-school and instruction care included in these grant programs, support for charter schools, magnet schools, family engagement education, and a few other national activities. There's Title V, which includes programs to support rural education, and then I would also note Title VII, which is impact aid programs for areas that do not receive sufficient state and local tax dollars because they are operated in an area that's mostly owned by the federal government. So in order to receive funding for each of these programs, states must submit an application to the U.S. Department of Education and agree to the policy and reporting requirements that are included in each program. However, rather than apply for each program individually, Title I, Title II, Title III, states are offered the ability to submit a consolidated application for all the title programs in the ESEA to the U.S. Department of Education. All states have submitted a consolidated application and have been approved by the U.S. Department of Education. Now I want to provide a brief overview of the federal requirements in education law, focusing mostly on ESEA Title I. So the most notable and broad federal requirements for states come through participation in the Title IA program in the ESEA. In order to receive Title IA funding, states must set their own education-related goals and hold schools accountable for student outcomes, especially related to academic achievement. States are required to select standards, academic standards of their own choosing, and administer annual academics assessments in reading, mathematics, and science that are aligned to those standards. Reading and mathematics assessments must be administered in each of grades 3 through 8 and once during high school. The science assessment must be administered in grades 3 through 5, 6 through 9, and 10 through 12, and that's once in those grades. In total, states must administer 17 annual assessments, although no individual student will take more than 3 of these in a given year. States must then implement an accountability system with weighted indicators that allows for meaningful differentiation to identify schools that need additional support to improve student achievement. Based on the accountability system, states must identify at least the lowest performing 5% of schools, among other improvement designations, in order to receive additional support and state-selected school improvement interventions. While these are the most notable requirements of federal education law, there are, of course, other policy assurances that states must make to receive funding through the many programs in the ESEA. So just sticking with the Title I program, a short list of other requirements would include that the state participate in the National Assessment of Education Progress, otherwise known as NAEP. These are math and reading tests that are given to 4th and 8th graders. They must also adhere to devising a plan to ensure that low-income and minority children enrolled in Title I-A schools are not served at disproportionate rates by, quote, ineffective, out-of-field, or inexperienced teachers. Another requirement is that they must ensure that any teacher or paraprofessional working in a program supported with federal funds meets applicable state certification and licensure requirements. There are broader requirements that apply to all ESEA programs that include a requirement that LEAs, local education agencies receiving ESEA funds, certify that to their state education agency that they do not limit, quote, the exercise of constitutionally protected prayer in public schools. There are also a number of local fiscal requirements that are required of school districts. This includes the maintenance of effort provision, which requires school districts to ensure that funding from state and local sources does not decrease by more than 10% from year to year. There's the supplement, not supplant provision, which requires that Title I-A funds be used so as to supplement and not supplant state and local funds that would otherwise be provided to Title I-A schools. And there's the comparability provision, which provides that a comparable level of services be provided with state and local funds in the Title I-A schools compared with the non-Title I-A schools prior to the receipt of Title I-A funds. Beyond just the Elementary and Secondary Education Act, the Individuals with Disabilities Education Act is the second largest education-related source of funding for the states. In exchange for receiving funding through IDA, states must agree to provide, quote, a free, appropriate public education, otherwise known as FAPE, to each qualified person with a disability who is in a school district's jurisdiction, regardless of the nature or severity of the person's disability. This is where things get a little more interesting. So providing a free, appropriate public education is also required by Section 504 of the Rehabilitation Act of 1973. So while IDEA is an education-specific grant program that contains more detailed requirements for providing this free, appropriate education, Section 504 applies to any program or activity receiving federal financial assistance. Now moving into the requirements of education-related civil rights laws. So the distinction between IDEA and Section 504, I think, serves as an important transition to the other federal laws that place requirements on elementary and secondary education. There are a number of education-related civil rights laws that will apply to this category, including, as I mentioned, Section 504 of the Rehabilitation Act of 1973, which prohibits discrimination based on a disability. There's Title 6 of the Civil Rights Act of 1964, which prohibits discrimination based on race, color, or national origin. And there's, of course, Title 9 of the Education Amendments Act of 1972, which prohibits discrimination based on sex. Requirements under these laws are generally not conditions of discrete federal education grant programs, but rather required for any activity or program, including in an education setting, that receives federal financial assistance. And federal financial assistance consists of a much more expansive set of funding streams than just those administered by the U.S. Department of Education. I've footnoted a link to the list of that definition that's, I think, believed provided by the Department of Justice. There are, of course, other federal education requirements that are settled in case law. For instance, the Supreme Court guaranteed the equal right to public education regardless of citizenship status in the Plyler v. Doe decision in 1982. I now want to move on to an overview of prohibitions on federal authority. So there are many requirements of states in federal law, but there are also a number of express prohibitions on federal authority that are expressed in law. A key understanding that I think emerges from these provisions, as you'll see, is that the federal government is expressly prohibited from determining what is taught in schools. So starting with ESEA Title I, Section 1604 and 1605, it contains two key prohibitions which are echoed at other points in the ESEA statute. And I'm going to quote directly from this. Nothing in this title shall be construed to authorize an officer or employee of the federal government to mandate, direct, or control a state, local education agency, or school's specific instructional content, academic achievement standards, and assessments. Also includes a prohibition stating that nothing in this title shall be construed to mandate equalized spending per pupil for a state, local education agency, or school. Exploring more prohibitions in the statute, we can look at ESEA Title II, Section 2302, which echoes Title I-A's prohibitions, but also adds additional prohibitions related to educators. It notes once more that the federal government cannot mandate, direct, or control a state, local education agency, or school's instructional content or materials, curriculum, program of instruction, academic standards, or academic assessments, a teacher, principal, or other school leader evaluation system, a specific definition of a teacher, principal, or other school leader effectiveness, or a teacher, principal, or other school leader professional standards, certification, or licensing. Finally, there's ESEA Title VIII, which is the general provisions section. It also outlines a series of prohibitions which apply to a state that accepts any funds under the ESEA and includes a prohibition on the use of ESEA funds to, quote, promote or encourage sexual activity, a prohibition on the federal control of educational curriculum, content or achievement standards, building standards, or allocation of resources. That echoes fairly similar to what you heard in the Title I prohibitions. And then finally also includes a prohibition related to the aiding and abetting of sex abuse. So I want to move on to the third charge of this task force, which is the feasibility of rejecting federal education funding. So while assessing the feasibility of rejecting federal education funding is a matter that is, of course, best left to this working group, I will offer some background on how other states have considered this matter and will briefly describe the consequences of noncompliance with federal law as I understand them. All states currently participate in the major federal education grant programs for elementary and secondary education. No state that we're aware of has ever chosen to no longer participate in any of the federal education grant programs that I've described. While information requests from legislators and legislative staff to NCSL are confidential, I can comment that NCSL does receive questions related to this matter before the task force from time to time. I am aware of public discussions that have taken place in Oklahoma this past legislative session related to a proposal, which is Senate Bill 863, which would create a plan to phase out federal education funding over a 10-year period. I don't believe that legislation was passed. Now, to our knowledge, the state legislative discussion of whether to continue to participate in federal education programs has not resulted in any specific actions taken by a state legislature, at least since the passage of the Every Student Succeeds Act in 2015. Of course, this is not to say that there have not been collective or specific conflicts between states and the U.S. Department of Education. Prior to the passage of the Every Student Succeeds Act, there were occasional instances where states refused to comply with some aspect of federal law, or at least courted the prospect of noncompliance. Washington State is the only state that we're aware of that has lost federal funds and temporary policy waivers due to their refusal to implement reforms regarding teacher evaluation, which are no longer a federal requirement. In 2005, the Utah State Legislature passed a bill that was signed into law that gave state officials the authority to ignore provisions of the previous iteration of the ESEA, No Child Left Behind, when they were found to be in conflict with state education laws and interests. However, I believe the state ultimately continued to participate in ESEA programs. In cases of non-compliance with federal law, the Federal General Education Provisions, otherwise known as GEPA, describes the authorities the U.S. Secretary has to administer federal education laws and regulations. Part D of the GEPA outlines the enforcement authorities afforded to the Secretary, which include the recovery of funds in instances of non-compliance. Specific consequences and the cadence of escalation in instances of noncompliance are going to vary on a case-by-case basis, and those are typically outlined in official letters from the Secretary. If the legislature chooses to go beyond noncompliance and reject select federal education programs in the ESEA, there are a number of questions that would need to be resolved with the U.S. Department of Education, as I understand it. In particular, there is some uncertainty about the consequences of non-participation in Title I-A, where many of the most significant requirements of federal education law are contained. Letters from a previous administration, I believe this was the Bush administration, Bush 42, indicated that the non-participation in ESEA Title I could have serious consequences for participating in the other ESEA title programs, especially for programs with statutory formulas for allocating funds that are based in part on the amount of funding that states receive under the Title I-A program. Finally, I'll move to the fourth charge of this task force and investigate some strategies for resolving conflicts with federal requirements. So, while I cannot recommend a specific strategy for this task force to pursue, I will describe 4 avenues the legislature could pursue to resolve any conflicts with federal law and the interests of the state. In this portion of my testimony, I am speaking from my perspective as the lead NCSL representative of the collective education interests of state legislatures before the federal government. So one option would be to exercise the flexibilities that are afforded in federal law. So this depends on the issue, but the ESEA does provide a number of flexibilities that states and local schools can enjoy upon request. For instance, with regard to federal assessment requirements, states are afforded the flexibility in federal law, to reduce testing time, implement locally selected, nationally recognized high school academic assessments, and offer statewide inter-assessments in lieu of a single summative assessment score. That'd be one option. Another option is to request a waiver from specific requirements. So under the ESEA, the U.S. Secretary of Education is authorized to waive most statutory and regulatory requirements associated with any program authorized by the ESEA if specifically requested by a state education agency. A state requesting a waiver must submit a waiver request with a plan that, among other requirements, identifies the federal program affected by the requested waiver, describes which federal statutory and regulatory requirements are to be waived, and describes how the waiving of such requirements will advance student achievement. A third strategy may be to seek changes through a reauthorization of federal law. The legislature could, of course, work with its U.S. congressional delegation to seek changes to federal law through a reauthorization of any number of the education laws that I've outlined today, almost all of which are due for reauthorization by Congress or overdue for reauthorization by Congress. As you're aware, U.S. Senator from Tennessee, Lamar Alexander, was considered the chief architect of the last major reauthorization of the ESEA, the Every Student Succeeds Act, in 2015. And then finally, another strategy would be to work with other state legislatures to explore changes to federal law through the NCSL Standing Committee on Education. The legislature could also work in collaboration and coordination with other state legislatures through the NCSL Standing Committee on Education to explore changes to current federal law. NCSL is a strong advocate for states on all policy matters, but especially education. We believe that states have the plenary authority over governing and financing education as delegated to states through the 10th Amendment of the Constitution. We acknowledge the necessity of cooperative federalism and work to ensure that federal education requirements best serve the collective education goals of state legislatures. To this end, NCSL was highly successful in shaping the last reauthorization of the Elementary and Secondary Education Act. During my tenure, NCSL has not been approached by any state legislatures to express broad and significant concern with the current state of federal education requirements in longstanding programs. However, we always stand ready to hear state concerns and seek appropriate avenues for addressing them with federal partners. The NCSL Standing Committee on Education maintains positions on federal education policy through its directive on the state-federal partnership in elementary and secondary education. And these policies, which are available on NCSL's website, state legislatures exhort the federal government to, quote, recognize that K-12 education is predominantly a state and local financial and legal responsibility. Federal spending is less than 10% of the nationwide K-12 budget and should not be used to exercise a disproportionate impact on education policy at the state and local level. We also exhort the federal government to, quote, avoid unfunded and underfunded mandates and fully fund the federal requirements for education programs, activities, and reporting. We exhort the federal government to, quote, encourage but do not mandate the policies and activities associated with federal education programs, regardless of funding levels. And finally, we exhort the federal government, quote, to respect state law and avoid inappropriate federal preemption. Any attempt to preempt should be balanced against the potential loss of accountability, innovation, and responsiveness. The NCSL Standing Committee on Education also believes that, quote, unless a clear and compelling case for national uniformity exists, every effort should be made to allow state governments to respond without federal intervention to local conditions. The federal government should specifically restrain involvement in state academic standards and assessments. State legislatures support the adoption and implementation of high quality and rigorous state academic assessments and standards as determined by state policymakers. The federal government should not, through legislative or regulatory action or funding opportunities, mandate, direct, control, coerce, or incentivize states to adopt a national set of common academic standards or common assessments. And you will see that those wishes are reflected in the prohibitions that are included in federal law. So, with conclusion, I thank this committee for inviting NCSL to testify on this matter. We always stand ready to help states understand their obligations under federal law and to serve as a vehicle for expressing the collective will of state legislatures on all matters of federal policy. I look forward to any questions that you may have and, of course, to following up with any additional research as requested.
Austin, thank you. That was very informative and insightful in many ways. Let's look to the committee to see what questions anybody may jump off with. Senator White, you're recognized, ma'am.
Thank you, Mr. Chairman, and thank you so much for this in-depth testimony that you gave. You said the four that Tennessee could look at working with the federal government. Has any other states been successful in working with, well, I know, like, you know, some of it is with our congressman, our congresswoman to change law, but any of the others, have any other states been successful?
Yeah, I could walk through the first couple of flexibility. So in terms of flexibilities afforded in federal law, yes, there has been some noted success. In fact, actually, depending on which flexibilities you're seeking, and I would say a lot of them do apply to the assessment rules, you're able to submit, an application to the department, and they will process that and hopefully approve. But we have seen a number of states seek out flexibilities in terms of offering statewide interim assessments in lieu of a single summative score. I believe Montana just received a pretty big waiver to implement a new assessment system, and they've received the ability to opt out of certain federal requirements for a couple years while they experiment with that. That was a pretty notable waiver. There's also something that I didn't note in here, which is the Innovative Assessment Demonstration Authority, which was considered to be 7 states to try new innovative ways of giving standardized assessments rather than just your fill-in-the-bubble tests. The department, I think, recently announced that they are lifting the cap of 7 states on that, so they're signaling that there's an interest in, I think, being a little more open to exploring certain flexibilities, at least as it relates to federal assessment requirements. So that would be sort of my response to at least exercising the flexibilities that are afforded in federal law. In terms of requesting a waiver from specific requirements, I think most of the requests have been related to the assessment requirements. Of course, before the passage of the Every Student Succeeds Act, there was a widespread waiver program from No Child Left Behind, but we haven't seen anything like that in the last few years. I don't believe that any state has really requested very broad opt-out of federal requirements. They tend to be sort of discrete, and there is, if you're interested, and I can follow up with this, there is a tracker on the federal education, the Department of Education's page that shows some of the requests that states have made in that. Most of them have related to I think the 1% annual testing cap on students with disabilities. So that's been most of the activity, although that's a pretty minor statute. In terms of seeking changes to the reauthorization of federal law, federal education law changes very slowly. The only 2 reauthorizations of the K-12 law happened in 2015 and then 2001. It is technically due for reauthorization. There's not presently a lot of conversation about reauthorization in Congress. That being said, when there is broad discontent expressed with the current status quo of federal education policy, certainly NCSL and other state organizations have had success in moving that forward. And of course, Lamar Alexander had particular success in moving that last reauthorization. And then in terms of working with other state legislatures, NCSL always stands ready to hear state concerns and see if those are reflected in other states, and can certainly adopt initiatives and opportunities for engagement that might forward those goals. For example, Senator Lundberg is a member of our higher education task force at NCSL, and we are exploring the state and federal relationship as it pertains to federal higher education policy. So it's an opportunity for us to take stock of that state-federal relationship and see how the state and federal role should evolve and be clarified. So we do not presently have an initiative like that in K-12, but should that be an expressed interest of many legislatures, we'd certainly be willing to look into that.
Thank you, Mr. Chairman. And one more question. You mentioned Montana, and they've got a waiver. Do you know how long the process was for the state of Montana to get that waiver testing and such?
I don't know with specificity, but I think they had a few months, close to a year maybe, of back and forth. Typically when you put a waiver in, you're likely going to have it's going to have to go through your state education agency. They're likely going to have conversations with back and forth with federal officials and sort of the lead up to the submission of that waiver. Sometimes there's a back and forth where the state will send in their waiver letter, and then the department will respond with some recommendations for maybe altering that waiver. So there can be a little bit of back and forth depending on the extent of the waiver request. And so in Montana's case, it was a pretty extensive waiver that they were asking for, and so I think that took a little longer to get through, but ultimately they were successful in being granted that. And that was actually a waiver that was asking for a program that was put in place with the coordination of the constitutional players in Montana, including the legislature and the governor's office of state education agency. And they had been putting in place a number of laws and practices for a few years to put them in position to be successful to get that specific waiver.
Again, thank you for your testimony.
Thank you.
It's been very informative.
Representative Reagan.
Thank you, Mr. Chair. Thank you for being here. Good to see you again.
Good to see you.
I have a series of questions for you. Let's start with the first one, where you mentioned that most states do a single request for the programs you were talking about. Are you familiar with any time when states have done single ones for the programs, Title 1A or whatever, and then not requested any others in relation to the funding?
I'm not aware of any state that's requested a waiver from the broad provisions of any specific title in ESEA, although based on how this is described, you could certainly you could specify which titles and which specific provisions. You could do it all in one waiver, or potentially, a series of smaller waivers, depending on how, you and the state agency would best think you could be successful in gaining that request.
Well, I wasn't really talking about a waiver per se. If I understood what you said, and correct me if I'm wrong, you were talking about when the states agreed to participate in these programs.
Oh.
And you mentioned the laundry list there, and you said, but nearly all states do it all at once because you can. So the question on the table is, if Tennessee chose to do cafeteria style, this one, not that one, this one, not that one kind of thing, what's the impact on that, especially with the comments you made related to specifically Title 1A, which has ties? So expand on that, please.
Yeah, I think this is a question that starts to push out of the policies that I can point to and into a little more speculation, which is where I typically think you get into where we need to have lawyers for the conversation, which I'm not really able to address. But as I understand it, in some of the conversations that I had with the time that I had to prep for this testimony, when you look through the statute of the ESEA, there are specific requirements and prohibitions for each of the programs, and it suggests that you could apply for them individually. And the question that I had, and I think it's the same one that you did, was whether or not the broad requirements of Title I would if opting out of that, would impact some of the other programs. And that would be up for the Department of Education to sort of, I think, articulate. We know from the past that there's been a suggestion that if you opt out of the Title 1A program, that it might impact participation in the other title programs. But this is sort of an open question. I think that there seems to be some room for the ability to choose this cafeteria style, but that's, I think, something that would have to be, no state has ever really approached this sort of question, and I think it would require a fair amount of back and forth between the department and states as to which title programs you're looking to opt into or opt out of, and moving forward from there. I don't have a good, that is frankly a question that does not have an answer yet. That would be an unknown that you would be entering into.
Let me follow on then with a related issue, perhaps more concrete, and that's the funding streams that flow from these title programs. It would seem fairly clear that if you're participating in this particular program and the funding stream is identified there and you're part of that one, that funding stream continues with that program. However, based on what you said, that doesn't seem to be the case. I mean, if you're doing pick a title and with 1A, since you mentioned that one, but you didn't want to do one of the others, and you said, no, I don't want to do that one, you can keep your funding for that one. Are they going to keep Title 1A funding too? Or are they still going to give it?
I think the question is whether, if you participate in Title 1A but opted out of some of the other programs, I think that would involve less complexity in terms of being able to opt out of those programs. But when it pertains to opting out of Title I, where most of the requirements are, then what that would mean for the other programs is more of the open question. I think it would be a little easier to stay in Title I and opt out of the other programs than it would to go vice versa.
If I might, Mr. Chair, are these authorizations a one-time deal, or does the state do it with the federal government every year? Each state every year? What?
The application process?
Yes.
It's not an annual. I don't believe it's an annual application. I think all states, prior to the passage of the Every Student Succeeds Act, had their new plans for the ESEA submitted by about 2019. States are provided the opportunity to submit amendments to their plans every year. Usually the department opens up some sort of time frame and an invitation to revise those plans and either modify the existing commitments that states have made through their plans or to communicate sort of other preferences that the state might have. But that's usually done more on an ad hoc basis during a specific window. I don't believe that states are recommitting and resubmitting these applications each year. So if you were going to go that route, then you would need to submit during that window and submit a new plan or an amended plan and then wait for feedback and back and forth from the department.
But the federal government sets that window. The state, we can't submit a letter to the federal government and say we want to change now. We have to wait for that window.
It's usually at an annual basis, but I think if you did invite that conversation, you would eventually lead into that window fairly quickly.
If I might, you mentioned unfunded mandates and the prohibitions against, as well as the other checks and balances on that one. However, a question arose on page 2 of your testimony. You mentioned the impacts on broader civil rights, such as Title IX, and on page 7 you mentioned it again, unfunded mandates. So a couple of direct questions related to that. Title IX requires educational institutions to have an OCR coordinator, a Title IX coordinator, and I think each higher education institution has their own. I believe our state education department maintains one to address all of the ones for the K through 12 system. But if that's mandated, does the federal government provide funding to pay for those coordinators?
So one, to clarify, NCSL's policy is, monitoring for unwarranted federal mandates. So it depends on the matter of whether, the legislatures believe those mandates are unwarranted. In this case, with these federal civil rights laws, states are receiving some form of federal financial assistance, maybe not to operate those programs, but are receiving some level of funding in order to be obligated under those requirements. I'm not an expert in Title IX administration and specific funding, so I'm not sure if I'm best qualified to answer that question. I can follow up with you on that in terms of what the funding looks like for providing those particular oversight capacities.
I would appreciate that, but related to that, yesterday and the day before we had discussions about the food program for students, free lunch, free breakfast kinds of things, and also that comes through the U.S. Department of Agriculture. It was mentioned the Defense Department funding for junior ROTC programs in the college. And I might also mention that at the college level, the Department of Energy provides a number of grants and research requests that affects our state directly, because the University of Tennessee has a cooperative agreement with the Oak Ridge National Laboratory, and those are very high dollar issues for us. But the question on the table is, if a Title IX violation is to be processed there, can the U.S. Department of Education say, we're going to hold your funding up for all of it? Not just what's within their bailiwick, but for the Department of Agriculture, the Department of Defense, the Department of Energy, et cetera.
I'm not sure on that question, but this may be helpful, and that I focus my testimony just on federal laws related to K-12. When we move into the higher ed space, there are a number of obligations that are placed on institutions of higher ed through the Higher Education Act. Typically, just as a broad understanding, most of the requirements for higher education, including Title IX, come through Title IV of the Higher Education Act, which includes all of the forms of federal financial assistance for college going. That includes the ability for institutions to accept federal student loans and to accept the Pell Grants. So the strings attached on the higher ed side of things tend to come through that financial assistance for students. And so, one crossover in the K-12 space is that for being recipients of federal financial aid, institutions that have a teacher prep program have to do certain reporting requirements on the nature of their programs to the Department of Education. That's not technically a K-12 law, but it does have a K-12 impact. So when you're looking at the broad applications of federal civil rights laws, I was just looking at K-12, but when you move into the other programs, that you're looking at a much more expansive set of programs with a much more expansive set of consequences.
Again, follow on for that. Tennessee has a program that I think we pioneered, but other states have adopted, called Middle College, where we allow high school students to be able to graduate from high school with an associate degree, which they take through the community colleges or our colleges of applied technology during the morning, and they go to high school during the afternoon, so that we have a mixture of college requirements and K through 12 requirements. So the question on the table relates to the mix and match that you just mentioned there. Where's the line drawn, and what are the impacts?
That would be, a question I think that would be best left to lawyers. But as I understand, when you look at the definitions provided on what constitutes federal financial assistance, it is fairly expansive, and I would think that some of the linking of multiple different systems and multiple different federal funding streams may mean that there, with regards to K-12 education, there may be a number of other funding streams that would give the federal government influence over specific aspects of the program that aren't just related to K-12. But I can't answer that specifically. I think that would be one of those questions that would sort of go beyond my understanding. And again, this would be sort of new territory, so I'm not sure if anybody has a great answer for that question, as there's not a lot of precedent for this.
Representative Reagan, may I come back to you in just a moment?
Go for it.
So, you open an interesting line of questioning, and let me tell the committee that Chair Lady Moody and I, when we received the letter appointing this working group, it does not clarify that this is just K-12. Some have said, well, should this be higher education? Candidly, we have focused, Chair Lady Moody and I have said, we interpret this to be K-12. Now, we can seek the speaker's input if they want to add higher education into this discussion. candidly, we realize the complexities of dealing with this issue on a K-12 basis. I would suggest to the committee that adding higher education into this could expand this committee and that scope and take us a long time to realize where we're going. If somebody wants to go there, please let me know. So after the meeting, and if I can, I'm going to come back to you, Representative Reagan. Senator Hensley, you're recognized, sir.
Thank you, Mr. Chairman, and thank you for being here today. But you mentioned several programs, but what we had heard previously that Tennessee got about $1.2 billion recurring money, and one of the biggest pots of that money, about 25–30%, was the school lunch program. And you didn't mention the school lunch program in some of these issues, but the question is, would we be able to still receive money for the school lunch program if we opted out of some of these other programs?
My understanding would be yes.
So
the reason I didn't focus that, I don't have as deep of an expertise in the administration of the school lunch and breakfast program. I have a little bit, but that is a separate program through the U.S. Department of Agriculture, as was mentioned. I don't believe that, receiving those funds are contingent upon adopting federal education programs through the U.S. Department of Education, but there may be something that I'm not aware of that link those two programs together, but as I sort of understand it, there's not a specific link or conditioning of if you receive, you can receive school lunch and breakfast program if you participate in the programs from the U.S. Department of Education.
So we would be able to continue to receive those funds if we opted out of some of these other programs.
That would be, I would believe so.
And one other question about the accountability. Do you have any idea about how much states spend on their accountability and monitoring these programs?
Yep. I do have a sense as part of the receipt of Title I-A funds, state education agencies do get an administrative set-aside, which provides a fair amount of funding or a reasonable amount of funding for operating that school accountability system. Within the Title I allocation of states, there's also a 7%, there's a mandated 7% set aside that goes towards specific activities for school improvement. So when a school is identified by improvement through the federal accountability system, they then, by the state's determination, gain access to those resources to carry out those interventions. So there is, the accountability system is baked into the funding that is provided through Title I-A, both from an administrative capacity, but also in an implementation capacity.
And you said that that's 7%? Is that what you said?
That's the minimum required set aside for school improvement activities.
Okay. And Tennessee changed their funding formula over the last couple of years, and so now each student generates so much money, and they generate so much according to their disability, certain different levels, and the higher level of disability, they receive more money. They receive more money if it's a Title I school, and so, but with our different funding formula, do you see that being an issue if we're funding students that way because we've been funding them? I assume the disability part is just a lump sum money, and now going forward it's going to be each student generates so much money. Do you see that change in how we're going to receive money going forward?
For longstanding federal education programs, there's no explicit connection between federal programs and state education finance law. There are a number of states that use proxies, federal proxies, to identify students for additional supports through the finance system. A weighted student funding formula, I think, is what you're describing. Right. So there are a number of states that use a student's participation in the school lunch and breakfast program as a proxy for them being a low-income student, which qualifies their school district for additional aid. I believe I didn't get to catch all of the testimony the last couple of days, but I believe that there's some level of identification of a student with disability through IDEA, through their IEP, that then qualifies them for additional weights and supports. But the understanding here is while states often do use those federal proxies. Those are not required by the federal government. They're essentially systems that are working in parallel, and the state is just using some of that federal data and identification to then operate their state finance law.
Okay, and you touched on one other thing, but states use the students that qualify for free and reduced lunches. That's what they base their Title I funds on.
That is one particular way to identify.
Okay. Thank you, Mr. Chairman.
Thank you. Representative Glenn, you're recognized, sir.
Thank you, Mr. Chairman, and thank you for coming, and it's a very detailed report you have here, and I appreciate that. So I have a few questions that I want to ask. In this brief, you basically state that Department of Education offers broad leadway. So that gives the state the opportunity to kind of set their own rules. Is that correct?
In terms of the waivers or just the general understanding of law?
Just the general understanding of.
So, coming out of the last reauthorization of the Every Student Succeeds Act, there was a general understanding that compared to previous federal education law, that this gave states a lot more authority in terms of setting how they operated most aspects of their education system as it relates to standards and assessments and accountability. I think it would best be described as the federal government sets broad parameters for what's expected of state education systems, but states are responsible for setting and monitoring their own education goals and then choosing their own academic standards, their own academic assessments, the instructional material, and then making determinations of school quality and student achievement that then play into the kind of activities they use to support those schools that may be deemed low performing under federal requirements. But there are many. One thing that gets interesting in this discussion is that there are many requirements that states place above the federal requirements. So in some ways, the federal requirements operate as a floor, but there are many states that include more accountability measures, additional assessments than what's actually required under federal law.
So from what I'm hearing, it's more the state has more strings attached to the money that they send down to the districts.
It depends.
Okay, got you. Have you found, or NCSL found, any unwarranted mandates from the federal government that you had to go back to the Fed and say, hey, we can't accept that? Have you found any unwarranted mandates?
During my tenure, which is close to 4 years now, we haven't found any. We haven't had any specific issues with the implementation of the Elementary and Secondary Act statutes or regulations thus far. We've lobbied on other K-12 provisions related to the ESSER program that are temporary, but as it relates to sort of longstanding federal law, we haven't noted any ongoing unwarranted mandates.
Okay.
That is not to say that there's not states that could feel that way, and certainly we'd look into that if it was identified, but we have not identified any, and nor have states brought to us particular instances of unwarranted mandates.
Okay, thank you. What hardships, you speak on other states because you work with them, what other hardships have other states had that have caused, I mean, you mentioned some here, but been any that were just undoable?
Not that I'm aware of since the passage of the Every Student Succeeds Act. So this well, not newly, it's almost been 8 years since it was last reauthorized. There have not been any broad or significant concerns that we're aware of that have been expressed by states about the status quo of current federal law. There are, of course, because this is the United States education system, ongoing debates about the role of assessment and accountability in schools, and certainly there are a wide range of opinions that are expressed by legislators and legislators on that. But in terms of becoming a single articulated discontent with the status quo of federal education policy, and as it relates to K-12, I'm not aware of any broad and ongoing discussions. We always are monitoring for that. We understand that there's conversations about better ways to do student assessment, better ways to identify schools for support and improvement, but the basic frameworks, I think, still remain accepted by states at this time.
Okay. My last question, thank you, Mr. Chair. You mentioned that if we decide to reject the federal funds, that states could, or even one part that you could possibly affect other funds, correct?
It's certainly a possibility. Again, that sort of approach hasn't been taken by states in recent memory. I'm not aware of any states that have actually attempted to do that, and so the consequences would and the interpretation of those moves would fall to the Department of Education to interpret, again, based on some past letters we've received or past letters that I've seen from previous administrations. There's a suggestion that these various title programs in some capacities are linked, and so opting out of one may impact participation in the other in the eyes of the Department of Education.
Okay, I'm concerned about that because my district in Montgomery County, we received impact funds, upward of over $1 million for our military service member kids. And so the thought of losing that affects me. And so I'm very, very concerned about this ideal of rejecting federal funds. Thank you. Thank you, Mr. Chair.
Thank you. Representative Reagan, I did cut you off before. I just wanted some others to have an opportunity. You're recognized, sir.
Thank you, and I agree, they need the opportunity too. To tie some ribbons on some of the issues that were brought up, you mentioned a 7% federal allowance, I guess, a lack of a better description, for administrative allowance. Is that across the board for states to administer these federal education programs, or is that specifically tied to individual ones? What is that?
Yeah, there's a separate, so there's two set-asides. There's a state administrative set-aside. I can't remember what percent it is. It's not a tremendous, it's like maybe 1-2%. I'll have to follow up with you on that. And that's for state administrative purposes. The 7% is for activities related to school improvement. And so of the total Title I allocation that a state receives, the state reserves 7%. That pool of money is the minimum amount that the state is supposed to make available to schools that are identified for improvement activities based on a variety of different improvement designations. How that money is actually allocated out from that 7% set aside is up to the state to determine. There's a lot of different strategies that states take to allocating those funds. They're able to operate that as a formula grant and say, for these, if you are identified for this particular improvement status, you will receive X, Y, and Z funding. Other states actually implement a competitive grant process where they identify the schools for improvement and then make their receipt of federal funds for improvement contingent upon some sort of application process that they put together as a state. But the allocation of that 7% set aside for school improvement is done at the behest of the state and does serve as a minimum floor. There are opportunities to use other federal funds in support of those school improvement activities, so that's certainly not a minimum amount. Another thing that I didn't mention is that there are a number of federal competitive grant programs that are included in the ESEA. I could probably list a few of them if you're interested. I do know that Tennessee schools and the state agency have been fairly successful in receiving those. Those typically go towards long-term school improvement initiatives that support the development of educators and school districts. And so another question would be whether or not the state would maintain eligibility for those particular competitive grant programs if the state were not participate in certain titles within ESEA. As well as that, the state can apply for those grants, but so can individual districts. I don't know if the individual district's ability to receive those funds would be put in jeopardy, but that's certainly a question that you would want to look into, if that path were taken.
Again, I want some clarity, though, if you don't mind. You specifically said Title I. I'm interested across the board. This percentage you're talking about is with Title I. What about the other titles? Does the federal government give us administration fees or a boost, if you will?
That's something I'll follow up with you in writing. I don't know that off the top of my head in terms of the administrative set aside for each of the other titles. I would presume that the majority of that's going to come through Title I. That is the vast majority of the funding that the state will receive through those programs. But I will look into whether or not there are additional administrative set asides included in each of those other title programs.
I would greatly appreciate that. And one final question, if you mind. Don't mind, sir. The clarity again on the issue of the Department of Education being able to say, U.S. Department of Education will disallow federal funds from all sources if we find that Tennessee is not complying with what we've said. It seems to fly in the face of common sense, and you indicated earlier that the Department of Agriculture wouldn't be affected. We could probably make the leap that the Department of Defense and Department of Energy wouldn't be affected. But yesterday we heard testimony that the U.S. Department of Education would be able to turn the spigot off on all those. So can you comment on that?
I don't know if anyone has a perfect answer for that question, but I understand that participation in the various programs offered by the U.S. Department of Education are applied to on your application, and your participation in those programs is contained within that particular program. So there is the question of whether or not the various titles of ESEA participation in those titles would impact participation in the other titles. But moving from the Elementary and Secondary Education Act over into the Carl Perkins Act or the McKinney-Vento Act, I'm not sure which particular aspects of those laws would be linked to participation in the K-12 laws. Again, no states opted out of any of these laws, so it's hard to speak there, but I would assume that that participation in any federal program is voluntary for any state, and that one not participating in a K-12 program wouldn't necessarily impact the participation in the career and technical education program, but there may be a number of links and intricacies that haven't been explored or I'm not aware of that could link them together. So again, this would be going down that path would reveal a number of different answers. I think that's again for probably administrative law experts and lawyers to answer. It's not something that I certainly have the expertise to go in on, but I would presume that that participation in each of those federal programs that are in law would be separate from each other. It's just a question of whether or not various programs within a single law would impact the others.
Thank you. Thank you, Mr. Chair.
Thank you. Austin, I have a couple of questions for you. I think they're fairly easy and broad. First off, you talked about some of the waivers, and waivers from your testimony, what I'm gathering, are not uncommon at all across the board. My question is, some of those waivers, you talked about a specific time frame. I think you mentioned Montana, while they did some accountability and they were doing some testing to clarify what they want to do or perfect it. Have any of those waivers been a permanent waiver?
Not that I'm aware of.
Okay. And you discussed Montana as well. I forgot the Senate bill number that you said didn't pass. Any chance you recall any of the conversation of why they wanted to phase out federal funding over a 10-year period?
The one in Oklahoma?
Oklahoma. My apologies, yes.
I just noted that they had that bill for the testimony. I was not actively following those conversations, so I don't know the specific motivations behind why they were raising that particular issue. Just know that they were raising it.
Okay.
Or a legislator introduced a piece of legislation.
Thank you. Thank you. Other questions from the committee? Seeing none. Austin, thank you very much. I appreciate it. Very informative. To members of the working group, I will tell you the Federal Department of Education has informed us they are unable to attend our task force meeting. They can only offer, quote, technical assistance to the committee. And they have stated that if members wish to submit questions, they will do their best to get them answered. If members want to submit questions, I would ask that you provide them to my office or Chair Lady Moody's office, and we will submit them, and any answers received will be in the task force report. If we can get the answers quickly enough, although I suspect those might not be by next week, so, but hopefully by the end of the year. So, nothing else before our agenda. Chair Lady Moody? Okay. Anything else to come before the committee today? So, Senator Ackberry, you recognize, ma'am?
Thank you, Mr. Chair, and I just wanted to let the committee know I will not be here next week. I have a previous engagement that was confirmed in June, and so I need to fulfill that obligation, but we'll certainly be watching and here in spirit. Thank you, Mr. Chair.
Thank you. Without objection, then, we are adjourned.